Morning. Today we are going to analyze one problem question and one theory question on freehold covenants. The problem question is being analyzed based on different aspects of freehold covenants. Please go through the disclaimer. The video content has been made available for informational and educational purpose only. Let's move on to the question. Roy was a registered owner of two neighboring properties in the same street, a butcher shop called Roy's Ribs and a cabin, the dilapidated shop that had previously been used as a news agent's. Molly wanted to demolish the cabin and build the escape room on the site. In 2016, Roy sold the registered freehold title of the cabin to Molly. As part of the transaction, Molly covenanted for Roy's benefit and the benefit of the land that he retained to build only one building on the site of the cabin, to plant and maintain a row of laurel bushes between the cabin and Roy's ribs. And third one is to contribute to the cost of maintaining the alleyway at the rear of both the properties and over which both properties have a right of way. So I repeat, the conditions are there should be only one building and it has to be planted and maintained bushes and he has to contribute to the for the maintenance. These are the three conditions. In 2017, Molly planted the row of floral bushes, after which she was not able to do anything further with the cabin because she had to assume the responsibility of looking after her elderly father. Late in 2022, Molly was forced to abandon her business plans to open an escape room. She therefore sold the cabin and to Callum. Roy has become concerned by a number of problems that have arisen in respect of Callum's use of the cabin. First, Callum has refused to maintain the laurel bushes between the two properties. Secondly, Callum has demolished the cabin and started to build two houses on the land. Thirdly, he has refused to contribute to the cost of resurfacing the alleyway, even though lorries he used for his building work have damaged its surface. We have to advise Roy. The key issue here is the freehold covenants created when the Roy sold the registered freehold title to the cabin and to the Molly. The covenant agreed upon between Roy and the Molly are to build only one building on the site of the cabin, to plant and maintain a row of laurel bushes between the cabin and the Roy's ribs, to contribute the cost of maintaining the alleyway at the rear of both the properties. These covenants were intended to benefit Roy and the land that he retained, that is, Roy's ribs. Pausing the benefit of the covenant. Based on the principles established in the case law, Tolk versus Mokshay, Astorbury versus Oldham Corporations, and Roney versus Stephens, the benefit of the covenant can pass to the subsequent owners of the servient land if the following requirements are met. The covenant must touch and concern the land. The covenant must have been made for the benefit of the dominant land. The benefit of the covenant must have been properly annexed to the dominant land. Let's compare the principles established by the aforementioned the cases in our case. The covenants created by Roy and Molly should be enforceable against Callum, the current owner of the cabin, as he acquired the property with notice of covenants. Callum's actions in refusing to maintain the laurel bushes, demolishing the building, and refusing to contribute to the alleyways maintenance are likely in the breach of the covenants. Roy, as a owner of the dominant land, should be able to seek enforcement of the covenants against the Callum under the principle established in cases like P&A Swift Investments versus Combined English Stores Group and Haywood versus Brunswick PBS. Callum may attempt to raise defenses such as laches, the unreasonable delay in enforcement, or personal bar, Molly's inaction, as discussed in Roque versus Chada and the Crust, Nicholson versus McAllister. However, given the relatively the recent nature of the events and the Molly's inability to act due to her father's illness, these defenses may not be successful. Passing of the burden and equity. The covenant placed by Roy and Molly is negative in nature, as it restricts Molly from building more than one building on the site and requires her to maintain the laurel bushes and contribute the alleyway maintenance. The covenant touches and concerns the land of the cabin, as it directly related to the use and maintenance of the property. The covenant is intended to protect Roy's neighboring properties, that is, Roy's ribs. The covenant was intended to run with the land, as evidenced by the language for Roy's benefit and the benefit of the land that he retained. Callum, as a successor in title to Molly, has notice of the covenant, as it was a part of the transaction when Molly purchased the cabin. Therefore, the burden of the covenant should pass to Callum under the principles established in Turk versus Mokshe and subsequent cases. Let's look into the positive and negative covenants. The covenant to maintain the laurel bushes and to contribute to the alleyway maintenance are negative in nature as they restrict Callum's use of the land. The covenants to build only one building on the site is also negative in nature as it restricts Callum's development rights. Therefore, these covenants should be enforceable against Callum as a successor in title, as per the principles outlined in Roney versus Stephens. Roy's ribs can be considered as a dominant tenement as the covenant is intended to benefit that property. The cabin is a servant tenement as it burdened by the covenant. So this is in line with the principles established in the London County Council versus Allen and Newton about case Cooperative Society Limited versus Williamson and Ted Gold Limited. Let's look into what the Act says. Since the covenant was entered into after the 1925, it is presumed to have been intended to run with the land. In the absence of any contrary intentions, that is Section 79 of LPA 1925. As the covenant was entered into after the enactment of LRA 2002, it needs to be protected by the entry of a notice on the registered title of the cabin in order to bind Callum as a successor in title. When Molly purchased the cabin from Roy in 2016, the covenant for Roy's benefit and the benefit of the land that he retained, that is, to build only one building on the site, to plant and maintain the row of bushes, to contribute the cost of maintaining the alleyway, these covenants are considered freehold covenants, as they were made in relation to the freehold ownership of the land. The key cases to consider are Turk versus Moksha versus Ashbury versus Oldham Corporations, which establish the principle for the passing of the benefit and the burden of the freehold covenants. The benefit of the covenants made by Morley has likely passed to Roy as a owner of the neighboring property, that is Roy's Ribs. The burden of covenants has likely passed to Callum as a successor entitled to Morley's ownership of the cabin. Enforceability of the covenants. Roy can likely enforce the covenants against the Callum as the successor entitled to Molly's land. The covenants are specific and relate to the use and maintenance of the land, which aligns with the principles established in cases like Roney versus Stevens and Haywood versus Brunswick. The covenants appear to be reasonable and do not impose an undue burden on the land, in line with the balance sought in cases like P&A Swift Investments versus Combined English Stores Group. Callum's breach of covenants. The Callum's actions in refusing to maintain the laurel bushes, demolishing the cabin, and building the two houses, and refusing to contribute to the alleyway maintenance all appear to be in the breach of covenants. This breach can likely be enforced by the Roy. As a beneficiary of the covenants, based on the principle established in cases like Smith and Snipes, Hall Farm Limited versus River Douglas Catchment Board, and the Federated Homes versus Mill Lodge Properties. So, what are the remedies available? Roy was maybe able to seek remedies such as injunction to compel the Callum to comply with the covenants as per the principles in Rourke versus Cheddar and the Crest Nicholson versus McAllister. Roy may also be able to seek damages from Callum for the breach of covenants in accordance with the principles in Newton Abbott Cooperative Society Limited versus Williamson and Chet Gold Limited and Halsell versus Brizzle. How the passing of the benefit of the covenants works. Under the Section 56 of the Law of the Property Acts 1925, LPA 1925, allows the benefit of the covenant to be enforced by a person who is not an original party of the covenant if the covenant was made with them rather than simply for the benefit. The court have interpreted this narrowly to only apply where the covenants had been can be seen as made with rather than just for the claimant. This would likely not apply to Roy, as he was not a original party to the covenant between the Morley and the Callum. The Contract Rights of the Third Parties Act 1999 may be more helpful. Under this act, a third party can enforce a contract if it is expressly provides they may do so, or if it purports to confer a benefit on them, and they are identified by the name descriptions as a member of the class. Since the covenant was made for Roy's benefit, this may allow Roy to enforce its against Callum. Successor in title. For the benefit of the covenant to pass to Roy as a successor in title, the common law requirements must first be met. The covenant must touch and concern the land, which appears to be the case here based on the requirements set out in the case like Swift Investments versus Combined English Stores. Both Molly and Roy must have a legal estate in the land which is satisfied as they owned the neighboring properties. It must have been the intention of the original parties for the covenant to run with the land, which may be implied from the nature of covenants. Once the common law requirements are met, the benefit can pass to Roy either by express assignment or by the annexation. For example, express assignment, the Molly would need to have expressly assigned the benefit of the covenant to Roy in writing, with a notice given to Callum. This seems unlikely to have occurred. Annexation. The benefit of the covenant may have been annexed to Molly's land, Roy's ribs, either expressly by the parties or statutorily under Section 78 of LPA 1925. This means the benefit would pass to Roy as the owner of that land. Let's look into the annexations and the enforceability. The covenant between Roy and Molly regarding the cabin property was expressly annexed to the land that Roy retained, the butcher shop's Roy's ribs. This can be inferred from the wording of the covenant, which said that it is for the Roy's benefit and the benefit of the land that he retained. The case law in Turk versus Merkshire and the Asbury versus Oldham Corporations and Federated Homes versus Mill Lodge Property supports the idea that covenant can be annexed to the dominant land through express words indicating an intention to benefit the land. Additionally, even if the intention to annex the covenant was not expressed, it could potentially be implied from the terms of the transaction. The case of Crest Nicholson versus McAllister suggests that the covenant must identify the benefited land so that it is readily ascertainable. Let's see how it goes with the enforceability of the covenants. The covenants imposed by Morley on the cabin property in favor of Roy's ribs are likely enforceable as a touch and the concern the land. In accordance with the principle established in the cases like Haywood versus Burnwick's Permanent Building Society and P&A Swift Investment versus Combined English Stores Group. The covenants regarding the maintenance of the laurel bushes and the contribution to the alleyways upkeeps are likely enforceable as they directly relate to the use and enjoyment of the properties involved. The covenant restricting the Molly to build only one building on the site of the cabin is also likely enforceable as it relates to the physical use and the development of the land. Potential differences and considerations. Callum may try to argue that covenants were unreasonable or against the public policy, as discussed in cases like Roney versus Stephenson and Newton Abbott Cooperative Society Limited versus Williamson and Treadgold Limited. However, the covenants case is appear to be reasonable and relatively direct to the enjoyment of the properties. Callum may also try to argue that covenant should not be enforceable against him as a subsequent purchaser, as discussed in Roque versus Chada and Thamesmead Town versus Alatoy. However, the express annexations of the covenants, the dominant land would likely undermine this argument. Roy may also be able to rely on the contract, the right of the Third Parties Act 1999, to enforce a covenant, as he was expressly identified as a beneficiary of the covenants in the transactions between the Morley and the Callum. So in this slide, we are looking into from the Callum's perspective how he will make a defense and how the Roy can counter defense. Let's analyze the same case based on the scheme of development. The key issue whether the covenants imposed by Molly in favor of Roy's rib property can be enforced against Callum, the new owner of the cabin. The passage indicates that Molly covenanted with Roy for the benefit of the land that he retained the Roy's ribs. This suggests the potential existence of scheme of development that could allow the covenants to be enforceable. The requirement for valid scheme of development as established in Ellistone versus Reacher and subsequent cases includes a single original seller of all the land within the scheme, plots of the land laid out in advance, the mutual restrictions established by the original seller for the mutual benefit of all the buyers, the purchaser's knowledge of mutually binding nature of the covenants, and the clear definitions of the scheme area. The potential arguments will be if a valid scheme of development can be established, Roy may be able to enforce the covenants against Callum as a new owner of the cabin. The covenants regarding the laurel bushes and the contribution of the alleyway maintenance could potentially be enforced under the scheme of development. However, the covenant limiting the Callum to building only one building on the site may face more difficulties as the courts have been more reluctant to enforce the restrictions on the use of the land in recent years. This is based upon the Haywood versus Brunswick case. What is the advice to Roy? Roy should gather more information about the original sale and the development of the properties to determine if a valid scheme of development can be established. If a scheme of development can be proven, Roy may be able to enforce the covenants against the Callum, particularly those related to laurel bushes and alleyway maintenance. The covenant, the limiting the number of buildings on the site, may be more challenging to enforce, as Roy should consider negotiating with Callum to find a mutually agreeable solution. How the passing of the burden of the covenant at law works. The general rule is that the burden of the covenant cannot pass at the law to the covenant successors in title as established in Ashbury versus Earldom Corporations and confirmed in Droney versus Stephens. This rule has been widely criticized as it prevents the land from being effectively burdened indefinitely. Various workarounds have been developed, including the using the leasehold covenants, common hold arrangements, conditional fee simples, indemnity clauses, and the doctrine of mutual benefit and burden, as seen in Halsall versus Bristle case. The doctrine of the mutual benefit and the burden requires that benefit and the burden be conferred by the same transaction, be related or linked, and allow the burden party the right to reject or disclaim the burden. Common hold was introduced to try to overcome the Ronnie versus Stephens obstacle, but it has not been widely adapted so far. The Molly covenanted with the Roy for certain obligations. When she purchased the cabin, they included in building one building, maintaining the laurel bushes, and contributing to alleyway maintenance. When Molly sold the cabin to Callum, the burden of the covenants did not automatically pass to Callum at law. So Callum has refused to maintain the laurel bushes, demolished the cabin, and built two houses, and refused to contribute to alleyway resurfacing. The main reason is that it did not automatically pass to Callum by law. So, what are the potential options for the Roy? Roy may be able to enforce the covenants against the Callum through the doctrine of mutual benefit and burden if the requirements are satisfied. Roy could also look to any indemnity clauses in the original sale to Molly that may allow him to claim against her for Callum's breach. As a last resort, Roy may be able to claim damages against the original covenanter, the Molly, for her failure to ensure the covenants would bind the Callum. The covenants. Molly covenanted with Roy for the benefit of his retained land, the Roy's ribs, and his benefit, to build only one building on the site of the cabin, to plant and maintain a row of laurel bushes, and to contribute to the cost of maintaining the alleyway at the rear of both the property. So, how to enforce these covenants? As a original covenantee, the Roy is entitled to enforce the covenantee against the Molly and her successors in title, such as Callum. The covenants run with the land and bind the Callum as the new owner of the cabin. Roy can seek to enforce covenants against Callum through the courts. What are the potential differences and modifications? Callum may argue that covenants are absolute or that enforcing them would be against the public interest. However, the courts tend to take a restrictive approach to modifying or destroying the covenants under Section 84(1) of the Law of the Property Act 1925. Callum may also argue that Roy has abandoned or waived his rights to enforce the covenants due to inaction. As in Chatsworth Estates Limited Co. versus Farewell, However, this is unlikely to succeed given that Molly had only recently breached the covenants. The court may be more willing to award damages rather than an injunction, as in Shaw versus Applegate. If Callum has been lulled into a false sense of security by Roy's inaction, what are the potential remedies? Roy can seek an injunction to compel Callum to maintain the laurel bushes and to contribute to alleyway maintenance. Roy may also be able to seek an injunction to prevent Callum from building two houses on the land, as this would breach the covenant to build only one building. If the courts are unwilling to grant an injunction, Roy may be able to recover damages from the Callum for the breach of the covenants. Hence, by this argument, we are concluding the analysis of problem question, and let's move on to the theory question. Theory question. It's the briefly comment on the view that Federated Homes Limited versus Mill Lodge Properties Limited in 1980 has radically altered the law relating to the running of the benefit of a freehold covenant. Let's analyze this theoretical question. Prior to this case, the federated homes, the general principle was that the benefit of the freehold covenant could only run with the land in limited circumstances, as established in the earlier cases of Tolk versus Mokshai in 1848. The federated homes case, however, introduced a more flexible approach. A key points from the federated home case are the court held that the benefit of the freehold covenant can run with the land, even if the land, even if the covenant does not touch and concern the land. This was a departure from the traditional touch and concern requirements. The court established that the crucial factor is whether the parties intended the benefit of the covenant to run with the land. This is determined by examining the wording of the covenant and the surrounding circumstances. The case expanded the circumstances in which the benefit of the covenant can be enforced by the successor in title, moving away from the more restrictive approach previously taken. This decision provided more flexibility in the enforcement of the freehold covenants and allowed for a more contextual case by case analysis of whether the benefit of the covenant should run with the land. The Federated Homes case was a significant development in the law of the freehold covenants, marking a shift towards a more liberal and pragmatic approach to determining the enforceability of the benefit of such covenants. This case continues to be an important precedent in the area of property law. What are the practical effects of federated homes between 1980 and 2004? The decision is federated homes apparently meant that whenever a restrictive covenant had been entered into after 1925, that covenant was automatically annexed to each and every part of the land, which is covenantee retained in the vicinity of the Soviet land. A consequence of Brightman LJ, leaving open the issue of the identifying the benefited land is that it was not clear in what manner the dominant land should be identified. For example, should the land be identifiable for the covenant from the covenant, the conveyance, or the evidence from the surrounding circumstances? In order for the benefit of the covenant to pass automatically under the statutory annexation, there must be nothing in the covenant which excludes its application. Brighton LJ stated that a covenantee may expressly or by necessary implication retain the benefit of the covenant wholly under his own control, so that the benefit will not pass unless the covenantee chooses to assign. Consequently, the benefit will not pass by statutory annexation if it is clear that it should only pass through express assignment. So, what is the criticism in this case? Federated homes apparently greatly simplified the law and restricted covenants, but it is not without criticism problems. Go provides a useful critique of this case. First, it is said that if the decision is correct, then there will be no need for the device of express assignment and express or implied annexations. Secondly, the Law of Property Act 1925 is a consolidated act which does not normally change the law unless the words clearly constrain the court to do so. If the words are capable of more than one construction, then the court should give effect to the construction which does not change the law. This is a strong argument with a narrow view. If the parliament intended to change the law, one would expect this to be expressed in unambiguous terms. Thirdly, if federated homes, the defendant, was the original covenanter, it was a case between the original covenanter and the successor in title of the original covenantee. The benefit could have run at a common law, and there is no need for the court to consider the running of the benefit in equity. Therefore, any subsequent court may treat the dictum of Brigham LJ regarding the statutory annexation under the section 78 as merely obiter dicta. The benefit of the covenant would pass with the land at a common law under Section 78 of the Law of the Property Law 1925. However, the burden of the covenant would not pass at the common law, despite the provisions under the Section 79 of LPA 1925, as clarified in Roney v. Stevens 1944. The benefit of the covenant could also pass in equity through annexations, assignment, or a building scheme. The only way for the burden of a negative covenant to pass was in equity under the principle established in Turquoise's Moksha. There was no way for the burden of a positive covenant to pass, even in equity, as confirmed in Roney versus Stephens. Let's see what are the significant changes. The Federated Homes Limited versus Mill Lodge Properties Limited decisions represented a significant change in the law. The key points are the Court of Appeal held that Section 78 of LPA 1925 could operate to annex the benefit of the covenant to the dominant land, even in the absence of express or implied annexations. The court emphasized that Section 78 only applies to covenants that touch and concern the dominant land. The court also explained that a covenant annexed to the dominant land by the Section 78 would be annexed to each part of the land, not just the whole. Therefore, a transfer of the part of the dominant land would occur the benefit of the covenants in relation to that part. Let's see what are the limitations. In Crest Nicholson Residential South Limited versus McAllister in 2004 case, the court held that for the Section 78 to apply, the instrument containing the covenant must identify the benefited land so that it is readily ascertainable. The courts have also confirmed in Rocky vs. Chada in 1984 and Crest Nicholson that the parties are free to expressly or impliedly exclude the operation of Section 78. Hence, we are going to conclude now. In summary, while the federated homes was a significant and controversial decision at the time, later cases have shown that its scope is somewhat limited, particularly with the requirement in Crest Nicholson that the benefited land can be clearly identified in the instrument. Thank you. So in this video, we have analyzed a problem question and a theoretical question. I hope it is useful for you. Thank you.